You are listening to HOA Storytime Central. The easement word came out like a curse. Angela shoved a pool safety rule page at me and yelled that my fence height was illegal in her opinion. She was already 6 inches into my personal space, the laminated sheet trembling in her fist, and her smartwatch was catching the early morning sun every time she jabbed her wrist at me for emphasis. "You picked the wrong corner to cut," she snapped, loud enough that my neighbor 2 houses down looked up from his recycling bin. I had just stepped outside to meet my fence contractor at 7 in the morning. The guy was scheduled to arrive at 7:15, and I needed to be on a video call by 8:30 because I work remote as a software developer, and clients do not care about HOA drama. Angela was already standing at the property line with a tape measure in one hand and that laminated policy sheet in the other. She claimed my fence was going to violate setback, height, and some vague aesthetic standard she refused to name. I pointed out that I had filed my application 3 weeks ago and received written approval from the HOA management company. She tapped her smartwatch like it gave her authority and said approvals mean nothing if the board does not ratify them, and the board had concerns. The contractor pulled up while she was mid-rant. He climbed out of his truck, took one look at Angela waving the laminated sheet, and asked if we had a problem. Angela pivoted immediately and told him that any work performed during quiet hours, which she defined as before 8 on weekdays, made the entire project illegal under community standards. The contractor checked his phone, showed her the work window I had cleared with the management company, and said he was starting at 7:30 as planned. Angela said she was calling management and she was going to be dramatic about it. She actually said that, word for word, like being dramatic was a threat instead of a warning. I live in St. Paul, Minnesota, in a subdivision where selective enforcement ramps up the moment you improve anything. The neighborhood is called Briarstone, and the HOA is Briarstone HOA Incorporated. I moved here 2 years ago because the mortgage was reasonable, and I thought a quiet street would be good for my custody and visitation routine with my daughter. I have her every other weekend and 2 evenings a week, and the schedule is strict because my ex and I worked it out in mediation with a deadline baked into the parenting plan. The HOA has targeted that schedule twice already. Once they towed my ex's car during drop-off because it was parked in a guest spot for 11 minutes over the 2-hour limit, and another time they sent me a violation notice for a chalk drawing my daughter did on the driveway during her visit. Both times Angela was copied on the emails, and both times the violations were quietly dropped after I replied with photos and timestamps proving the accusations were exaggerated. Angela unrolled her tape measure and stretched it along the fence line before the contractor had even unloaded his tools. She claimed the setback was wrong and demanded I show her the survey. I pulled out my phone and opened the PDF the surveyor emailed me last month. She squinted at the screen, tapped her smartwatch twice, and said digital copies do not count because anyone can edit a PDF. I asked her what she wanted instead. She said a printed plat map page with the county stamp visible, and she wanted it today. I told her I could print it tonight after my calls. She said tonight was too late because the hearing was scheduled for tomorrow, and I had been notified. I had not been notified. I checked my email right there on my phone. Nothing. She smirked and said the notice went to the address on file, which I knew was my address, and if I did not receive it, that was a mail issue, not an HOA issue. The contractor asked me if I wanted him to wait or start. I told him to start. Angela said if he started she would file an emergency injunction with the board and have the work stopped by the end of the day. The contractor sighed, told me he had 3 other jobs this week and could not afford to get dragged into HOA politics, and said he would come back when I had it sorted. He loaded his tools back into the truck and left. Angela folded her arms and said, "Make it public. I love watching people get embarrassed." I had 45 minutes before my first call. I went inside, logged into the HOA portal, and searched for any notice about a hearing. There was nothing. I checked my physical mailbox, empty except for a furniture catalog. I called the management company and got voicemail. I left a message asking for confirmation of the hearing Angela mentioned and requesting a copy of any notice they sent. Then I opened my laptop and started my day. By 9 that morning, I had 3 emails. One was from the management company saying they had no record of a hearing scheduled for tomorrow. One was from Angela, sent to the entire board and CCing me, claiming I had refused to comply with a lawful inspection and that my contractor had performed unpermitted work during quiet hours in violation of community peace standards. The third was from the board president, a guy named Greg who usually stayed neutral, saying the board would discuss my fence project at the next meeting in 2 weeks and I was welcome to attend. Angela replied within 6 minutes, demanding an emergency session because my project posed an immediate safety risk. Greg replied that safety risks required photographic evidence and a specific code citation. Angela attached 4 photos of my property line with the tape measure stretched across the grass at an angle I could already tell was wrong. I printed the survey and the approval letter. I also printed the timestamp metadata from the management company portal showing my application was submitted March 10th and approved March 14th. Then I grabbed my own tape measure and went outside. I measured the setback myself. It was exactly where the survey said it should be. Angela's tape measure in the photos was angled to make the distance look shorter. I took my own photos with the tape measure flat on the ground and the survey stake visible in the frame. I uploaded everything to the portal and emailed it to Greg with a note saying Angela's measurements were inaccurate and her photos were misleading. Angela sent another email an hour later. This one went to the full mailing list, which included every homeowner in the subdivision. The subject line was "Fence dispute requires community input." The body of the email said I was the one resident who refuses community standards, and she framed my fence as a precedent-setting violation that would lower property values and set a dangerous example for future projects. She included a link to a petition she had created asking the board to halt my project immediately. By lunch, 16 people had signed it. My friend Marcus called me that afternoon. Marcus works in IT, and we met at a local tech meetup a year ago. He lives 3 blocks away in a different subdivision, but he knows Angela because she tried to recruit him to serve on a neighborhood watch committee, and he declined after she asked him to report on people working from home during the day. Marcus said he saw the petition link in a group chat and noticed the email headers looked weird. He offered to check the metadata and timestamps if I forwarded him the chain. I sent him everything. He called me back 20 minutes later and said 2 of the emails Angela sent, including the one with the petition link, were backdated in the sent field, but the server logs showed they were actually composed and sent after I had already submitted my corrections to the portal. He said it looked like she was trying to create a narrative that I was unresponsive and combative, when in reality, I had replied faster than she expected. I thanked him and asked if he could write that up in a short summary I could forward to the board. He said he would send it tonight. I told him I owed him a beer. He laughed and said I owed him 3 beers if Angela tried to escalate again. Angela escalated. On Thursday, she sent an email to the management company with the board and me on copy, stating that because I had not responded to the compliance deadline, which she claimed was Wednesday at 5, the HOA was moving forward with collections on the fine she had assessed. The fine was $1,200. The email said the fine covered the unapproved setback, the noise violation from the contractor, and an administrative fee for emergency review. I replied immediately, pointing out that no hearing had occurred, no vote had been taken, and the fine had no basis in the bylaws. Angela replied that the Finance Committee, which she leads, had the authority to assess penalties without a vote when safety was involved, and my refusal to halt work constituted a safety issue. I pulled up the bylaws. The Finance Committee could assess late fees on unpaid dues. It could not assess fines for code violations. Those required a hearing and a board vote with a quorum. I highlighted the section, attached it to my reply, and said I was formally disputing the fine and requesting a hearing with the full board. Angela replied that the hearing was already scheduled for tomorrow night, Friday at 7, and I had been notified last week. I checked my email again. Still nothing. I called the management company again and left another voicemail. Then I checked the bylaws for the notice requirement. Hearings required 7 days written notice delivered by mail or email. Angela's email thread was the first mention of a hearing, and it was sent 4 days ago. I forwarded the bylaws excerpt to Greg and asked him to confirm whether the hearing was valid. Greg replied that he would look into it. Angela replied to Greg, copying everyone, and said she had hand-delivered a notice to my mailbox last Thursday, which would have been 8 days ago. I walked outside and checked my mailbox. There was no notice. I checked my front porch. Nothing. I texted my neighbor across the street, a retired guy named Dennis, who walks his dog every morning and usually waves when he sees me. I asked him if he had seen anyone at my mailbox last Thursday morning. He texted back that he remembered seeing Angela's car parked in front of my house for a few minutes around 8. But he did not see her at the mailbox. Friday morning, I received a certified letter from a collections agency. The letter said I owed $1,200 plus a $200 administrative fee for the collections referral, and I had 10 days to pay, or the HOA would file a lien on my property. I scanned the letter and emailed it to Greg, Marcus, and the management company with a note that said this was unlawful because the fine was under dispute and no hearing had been held. Marcus replied within minutes and said the collections letter was premature and probably unenforceable, but I should consult an attorney just to be safe. I did not have time to find an attorney before the hearing that night, so I printed every email, every photo, the survey, the approval letter, the bylaws excerpt, and Marcus's metadata summary. I put it all in a folder and planned to bring it to the meeting. If you are enjoying this story, hit the like button and subscribe for more satisfying HOA justice content. At 6:30, I got a text from Greg saying the meeting location had changed. It was no longer at the community center. Angela had moved it to her house. I asked why. Greg said Angela claimed the community center was double booked and her house was more convenient. I asked if that was allowed. Greg said the bylaws allowed emergency location changes with notice to all parties. I pointed out I was receiving notice 30 minutes before the meeting. Greg did not reply. I drove to Angela's house. She lived 4 streets over in a corner lot with a 2-car garage and a front yard full of decorative rocks. There were 6 cars parked on the street when I arrived. I recognized Greg's truck and 2 other board members I had seen at the annual meeting last year. I parked and walked up to the front door with my folder. Angela opened the door before I could knock. She was holding a laminated policy sheet, the same one from earlier in the week. She said the hearing was in the garage and I needed to wait outside until I was called. I asked why I could not sit in on the discussion. She said it was executive session and I would be allowed to present my case after the board had reviewed the evidence. I asked what evidence. She closed the door. I stood on the porch for 20 minutes. I could hear voices inside, but could not make out the words. At 7:15 the door opened, and Greg waved me in. The garage had been converted into a meeting space with folding chairs arranged in a U-shape and a folding table at the open end. Angela sat at the table with two other board members I did not recognize. Greg stood off to the side. Angela motioned for me to sit in the chair facing the table. I sat down and placed my folder on my lap. Angela said we were here to discuss my non-compliance with HOA standards and my refusal to halt unpermitted construction. I started to respond, and she held up her hand and said I would have 3 minutes to present my case after the board had asked their questions. One of the other board members, a woman named Linda, asked if I had received the notice about the hearing. I said no. Angela said she had hand-delivered it. I said I checked my mailbox and my porch and found nothing. Angela said that was not her problem. Linda asked if I had received the approval letter from the management company. I said yes and pulled it out of my folder. Angela said the approval letter was conditional and the conditions had not been met. I asked what conditions. She said the setback verification and the aesthetic review. I said the survey verified the setback and the approval letter did not mention an aesthetic review. Angela said aesthetic review was implied in the application process. I asked where that was written. She said it was standard practice. Greg stepped in and said he had reviewed the bylaws and the approval process did not include an aesthetic review unless the board voted to add one. Angela said the board had voted. Greg asked when. Angela said it was a voice vote at the March meeting. Greg said he did not recall that vote and asked if it was in the minutes. Angela said the minutes were still being finalized. Greg asked who took the minutes. Angela said she did. Greg said he wanted to see the draft before we continued. Angela said the draft was on her laptop inside and it would take a few minutes to retrieve. Greg said we could wait. Angela left the garage. Linda and the other board member, a man named Paul, both looked uncomfortable. Linda asked me if I had photos of the setback. I pulled out my printouts and handed them across the table. Linda looked at them and said the measurements looked correct to her. Paul said he was not qualified to judge a survey and we should defer to the professional. Angela returned with her laptop and placed it on the table. She opened a document and scrolled to a section near the bottom. She said the vote was recorded as a motion to adopt enhanced aesthetic standards for fence projects, and it passed 3-2. Greg leaned over and read the screen. He said the motion described in the draft minutes was about paint colors for exterior trim and had nothing to do with fences. Angela said the motion was broader than the title suggested. Greg said the title was the binding language and the board could not retroactively expand the scope of a motion. Angela closed the laptop and said we were wasting time on procedural details when the real issue was my refusal to cooperate. I said I had cooperated with every request. I filed my application on time. I received approval. I hired a licensed contractor. I provided the survey and photos proving the setback was correct. Angela said I had performed work during quiet hours. I said the contractor arrived at 7:30, which was within the approved work window. Angela said quiet hours were until 8. I asked where that was written. She handed me the laminated policy sheet. I scanned it and saw it was a pool safety rule page from a different HOA in a different state. I pointed that out. Angela snatched the sheet back and said it was an example of best practices. Greg said this was going off track. He asked Angela if she had any evidence that my fence project violated the bylaws or the approval conditions. Angela said the photographic evidence showed the setback was too narrow. I said her photos were taken at an angle. I pulled out my own photos and the survey side by side and pointed out that her tape measure was not flat on the ground. Linda looked at both sets of photos and said it was obvious the angle made a difference. Paul agreed. Angela said I had edited the photos. I said the metadata was included in the printouts and Marcus had verified the timestamps. Angela demanded to know who Marcus was. I said he was a friend who worked in IT and had offered to help me document the timeline. Angela said Marcus was not a board member and his opinion did not matter. Greg said the metadata was objective and we should accept it unless Angela had proof it was altered. Angela did not respond. Greg asked if there were any other issues to discuss. Angela said the fine was still valid because I had caused disruption and wasted board time. Greg said fines required a hearing and a vote, and we had not voted yet. He asked for a motion. No one moved. Greg said without a motion, the fine was void. Angela said the Finance Committee had already assessed it. Greg said the Finance Committee did not have that authority. He turned to me and said the fine would be removed from my account and I was clear to proceed with the fence project as approved. Angela stood up and said she was calling her attorney, and this was not over. She walked out of the garage. Linda and Paul both looked at Greg. Greg said the meeting was adjourned. I walked back to my car. My hands were shaking. I sat in the driver's seat and checked my phone. It was 7:55. I had a video call at 8:30 and I needed to get home. I started the engine and pulled out. Angela was standing on her front lawn with her phone pressed to her ear. She stared at me as I drove past. Saturday morning I called the contractor and asked if he was still willing to do the job. He said he heard Angela tried to intimidate him on camera and he did not want to deal with her again. I asked what he meant by on camera. He said Angela had shown up at his shop Friday afternoon with her phone recording and demanded to know why he was working with someone who violated HOA rules. She threatened to leave a bad review online and contact his other clients. He told her to leave and she refused until he threatened to call the police. He said he had enough work lined up and did not need the hassle. I apologized and said I understood. I asked if he knew anyone else who might take the job. He gave me 2 names and wished me luck. I called the first name. The guy listened to my summary and said he did not work in developments with active HOA disputes. I called the second name. She said the same thing. I spent the rest of Saturday searching for contractors online and calling every listing within 20 miles. 4 people said they were booked through summer. 3 said they did not do residential fences. 2 said they would not work in Briarstone because they had bad experiences with the HOA in the past. 1 guy said he would do it for double his usual rate because of the risk. I could not afford double. Sunday morning, I sat down with my laptop and started looking at the bylaws again. I wanted to understand what Angela could do next and what my options were. The bylaws had a section on dispute resolution that required mediation before any legal action. It also had a section on selective enforcement that said the board could not apply rules inconsistently or target individual homeowners without cause. I highlighted both sections and saved them to a new folder. Then I drafted an email to the board requesting a formal review of Angela's conduct, citing the fake fine, the fake hearing notice, the intimidation of my contractor, and the misleading photos. I attached Marcus's metadata summary and my own documentation. I sent it to Greg and CC'd the management company. Monday morning, I received an email from the management company. They said they had reviewed my complaint and determined that Angela's actions did not violate any specific bylaw because board members had discretion to assess compliance and initiate hearings. They recommended I attend the next board meeting to address my concerns in a public forum. The next meeting was not for another 10 days. I replied and asked if the management company planned to investigate the contractor intimidation or the fake collections referral. They said those were separate matters and I should file a police report if I believed a crime had occurred. I called the non-emergency police line and explained the situation. The dispatcher said HOA disputes were civil matters unless there was a threat of violence or evidence of fraud. I asked if fake fines counted as fraud. The dispatcher said I would need to speak to an officer and they would send someone to take a report. An officer arrived that afternoon. His name was Officer Daniels. He listened to my summary, looked at the collections letter, and said it was a civil issue unless I could prove Angela had intentionally fabricated the fine knowing it was unlawful. I showed him the bylaws excerpt and the hearing timeline. He said it was possible, but proving intent would be difficult. He said I should consult an attorney and consider filing a complaint with the State Consumer Protection Office if I believed the collections agency was acting unlawfully. He took notes and said he would file a report, but he could not take any enforcement action based on what I had shown him. I spent Monday night researching attorneys. I found 3 who listed HOA disputes as part of their practice. I called all 3 Tuesday morning. The first one said he was booked until June. The second one said his retainer was $5,000 and he did not think my case was strong enough to justify the cost. The third one, a woman named Ellen, said she would review my documents for a flat fee of $300 and give me an opinion on whether I had a viable claim. I agreed. I scanned everything and emailed it to her office. She called me back Wednesday afternoon and said I had a strong case for selective enforcement and potentially for tortious interference if I could prove Angela's actions caused me financial harm by scaring off contractors. She said the next step was to send a demand letter to the HOA requesting they remove the fine, issue a written apology, and adopt a policy preventing future retaliation. She said if they refused, I could file a complaint in small claims court or pursue mediation. I asked how much that would cost. She said small claims filing was about $200 and mediation was free if the HOA agreed to participate. She said most HOAs settled once an attorney got involved because the cost of defending a lawsuit was higher than the cost of settling. I asked her to draft the demand letter. She said she would have it ready by Friday. I thanked her and hung up. Then I checked my email and saw a new message from Angela. The subject line was final notice. The body of the email said I had 72 hours to pay the fine or the HOA would proceed with a lien filing. She attached a copy of the lien paperwork with my name and property address filled in. I forwarded it to Ellen immediately. She replied that the lien threat was almost certainly unenforceable and we should include it in the demand letter as evidence of harassment. Friday afternoon, Ellen emailed me the demand letter. It was 3 pages long and cited the bylaws, the timeline, the contractor intimidation, and the unlawful fine. It demanded the HOA remove the fine within 7 days, issue a written statement clarifying that my fence project was approved and compliant, and agree to a no retaliation policy with financial penalties if Angela continued to target me. The letter said if the HOA did not respond within 7 days, I would file a complaint in small claims court and seek damages for attorney fees, lost time, and emotional distress. Ellen said she would mail the letter certified and email a copy to the board and the management company. I approved it and paid her invoice. That night, I picked up my daughter for the weekend. She was excited because we had planned to visit the Science Museum on Saturday. I had not told her about the HOA situation because I did not want her to worry. We got home around 6 and I made dinner. While we were eating, my phone buzzed. It was a text from Greg. He said Angela had called an emergency board meeting for Sunday morning and I was invited to attend. I asked what the meeting was about. He said Angela wanted to discuss the demand letter and vote on a response. I said I would be there. Sunday morning, I dropped my daughter off at my ex's house and drove to the community center. The meeting was scheduled for 9. I arrived at 8:50 and saw Angela's car already parked in the front row. Greg's truck was next to it. I walked inside and found the meeting room. There were 8 people sitting in folding chairs arranged in a circle. Angela was at the head with her laptop open. Greg sat to her right. Linda and Paul were there, along with 3 other board members I had not met. Angela looked up when I walked in and said I was not allowed to sit in on executive session. Greg said this was not executive session, and I had been invited. Angela said the invitation was for after the board discussed the letter. Greg said the letter was addressed to me, and I had a right to be present. Angela closed her laptop and said fine. I sat down in the empty chair across from Angela. Greg said he had read the demand letter, and he thought the HOA should settle. He said my documentation was solid, and fighting it would cost more than removing the fine and issuing an apology. Angela said settling would set a precedent that any homeowner could ignore the rules and threaten legal action. Greg said I had not ignored the rules, and the fine was improper. Linda agreed. Paul said he was uncomfortable with how fast Angela had pushed the fine through. One of the other board members, a man named Steve, said he had not even known about the fine until he saw the demand letter. Angela said the Finance Committee had authority to act quickly in emergencies. Steve said this was not an emergency and the Finance Committee was supposed to report actions to the full board within 48 hours. Angela said she had sent an email. Steve said he never received it. Angela opened her laptop and said it was sent last Tuesday. Steve pulled out his phone and searched his inbox. He said there was no email from Angela on Tuesday. Angela said it must have gone to spam. Steve said he checked spam and it was not there either. Greg asked Angela to forward the email to the group. Angela said she would do it after the meeting. Greg said we could wait. Angela clicked on her laptop for a minute and then said the email was not in her sent folder and she must have forgotten to send it. Greg said that meant the Finance Committee action was not reported as required, and the fine was void regardless of whether it was proper in the first place. Angela said the fine was still valid because I had not appealed it within the required time frame. I said I had appealed it in writing the same day it was sent. Angela said my appeal was not submitted through the proper channel. I asked what the proper channel was. She said I was supposed to file a written appeal with the management company and request a hearing. I said I had done exactly that in my email to Greg and the management company. Greg confirmed he had received it and forwarded it to the management company. Angela said the management company had not forwarded it to her. Greg said that was not my fault. Linda said she wanted to vote on the demand letter. She moved that the HOA accept the terms, remove the fine, and issue a written apology. Paul seconded. Greg called for a vote. Linda, Paul, Steve, and 2 other board members voted yes. Angela voted no. 1 board member abstained. The motion passed 5-1. Angela said the vote was invalid because it was not on the agenda. Greg said emergency meetings allowed for agenda flexibility, and the vote was valid. Angela said she was resigning from the board effective immediately. Greg said that was her choice. Angela closed her laptop, stood up, and said I had just made a very powerful enemy. She walked out of the room. Greg said he would work with the management company to draft the apology letter and remove the fine from my account. He asked if I was satisfied with that outcome. I said I was as long as the no retaliation policy was included. Greg said it would be. Linda asked if I was still planning to build the fence. I said yes. She asked if I had found a contractor. I said not yet. Steve said his brother-in-law did fencing, and might be interested. He gave me a number. I thanked him. The meeting ended at 10:15. I walked out to my car and sat in the driver's seat for a minute. My hands were shaking again. I pulled out my phone and called Ellen. I told her the board had accepted the demand letter and removed the fine. She said that was a great outcome and I should get the apology in writing as soon as possible. I asked if I needed to do anything else. She said I should keep all the emails and documents in case Angela tried to retaliate. I said I would. She said if Angela contacted me directly, I should not engage and forward everything to Greg or the management company. I thanked her and hung up. Monday morning, I called Steve's brother-in-law. His name was Tom. He said he had heard about the situation from Steve and he was willing to do the job. He said his rate was standard and he did not charge extra for HOA drama. I asked when he could start. He said Thursday. I agreed and sent him the survey and the approval letter. He said he would bring his own tape measure. Thursday morning, Tom arrived at 7:30. He unloaded his tools and started measuring the fence line. I watched from the porch with a cup of coffee. At 8, Angela's car pulled up to the curb. She got out and walked across the lawn toward Tom. I put down my coffee and walked outside. Angela was already talking to Tom, holding up her phone and recording. She said he was trespassing on HOA common property and she was documenting it for legal purposes. Tom stopped measuring and asked her to clarify what she meant by common property. Angela said the setback area was maintained by the HOA and required board approval before any work could be performed. Tom said the survey showed the setback was on my property, not HOA property. Angela said the survey was wrong. Tom asked if she had a different survey. Angela said she did not need one because the plat map was clear. Tom asked if she had the plat map with her. Angela said it was at her house. Tom said he would wait while she got it. Angela walked back to her car. She returned 5 minutes later with a rolled-up paper. She spread it out on the hood of her car and pointed to a line near the bottom. She said the line marked the HOA easement and it extended 3 feet into my yard. Tom looked at the map and said the easement was for utility access, not setback, and it did not restrict fence placement. Angela said she was calling the city. Tom said that was fine and he would keep working while we waited. Angela called the city code enforcement office and put it on speaker. A woman answered and asked how she could help. Angela said she needed to report an illegal fence installation. The woman asked for the address. Angela gave my address. The woman said she would send an inspector out within 48 hours. Angela said 48 hours was too long and the work needed to stop immediately. The woman said code enforcement did not issue stop work orders over the phone, and the inspector would determine if a violation existed. Angela asked to speak to a supervisor. The woman said the supervisor was in a meeting and would call back later. Angela hung up and said the inspector would side with her. Tom shrugged and kept measuring. I went inside and called Ellen. I told her Angela was back and had called code enforcement. Ellen said that was fine because I had the approved survey and the city would confirm it. She said I should document everything Angela said and did in case we needed it later. I said I was already taking notes. She said good. I hung up and went back outside. Angela was standing at the fence line with her tape measure stretched across the grass at the same angle she had used in her earlier photos. I walked over and said if she was going to measure, the tape needed to be flat on the ground. Angela said she knew how to use a tape measure. I pulled out my phone and took a photo of her holding it at an angle. She saw me and said I was harassing her. I said I was documenting her harassment of me. She said she was calling the police. A squad car arrived 10 minutes later. Officer Daniels stepped out. He recognized me from the earlier report and asked what was going on. Angela said I was harassing her and interfering with her HOA duties. I said Angela was trespassing on my property and trying to stop legally approved work. Officer Daniels asked to see the approval letter. I pulled it up on my phone. He read it and asked Angela if she had any documentation that the work was not approved. Angela said the approval was conditional and the conditions were not met. Officer Daniels asked what conditions. Angela said the setback verification. Officer Daniels asked if I had a survey. I said yes, and showed him the survey on my phone. He looked at it and said it appeared to be in order. He asked Angela if she had any evidence that the survey was wrong. Angela said she had photos proving the setback was too narrow. Officer Daniels said photos were not the same as a professional survey. He turned to Angela and said the HOA was not a law enforcement agency and she needed to stop interfering with the contractor's work. He said if she continued, he would cite her for trespassing. Angela said she was exercising her rights as a board member. Officer Daniels said she was no longer a board member according to the meeting minutes I had forwarded to the department. Angela said the minutes were not official. Officer Daniels said he was not going to argue about HOA politics and she needed to leave the property. Angela said she was calling her attorney and this was not over. She walked back to her car and drove away. Tom said he appreciated the backup and asked if this kind of thing happened often. I said more often than I would like. He laughed and said he had worked in plenty of developments, but this was the first time he had seen a cop show up before lunch. He went back to work and finished the measurements by noon. He said he would start digging post holes tomorrow and the fence would be done by the end of the week. Friday morning, I received an email from the management company. They said the board had drafted the apology letter and it was attached. I opened the attachment. The letter said the HOA regretted any confusion regarding my fence project and confirmed that the project was approved and compliant with all applicable bylaws. It said the fine had been removed from my account and I would not be charged any administrative fees. It also said the board had adopted a new policy prohibiting retaliation against homeowners who exercise their rights under the bylaws, with financial penalties for any board member who violated the policy. The letter was signed by Greg as board president. I printed it and filed it with the rest of my documentation. Tom finished the fence on Saturday. It looked great. The posts were straight, the panels were level, and the setback matched the survey exactly. I paid Tom and thanked him for sticking with the job despite Angela's interference. He said it was no problem and he hoped I did not have any more trouble. I said I hoped so too. Sunday morning I was drinking coffee on my back deck when I heard a car pull up in front of the house. I walked around to the front yard and saw Angela standing on the sidewalk with her phone out. She was taking photos of the fence. I walked over and asked what she was doing. She said she was documenting the violation for her attorney. I said there was no violation and the fence was approved. She said the approval was fraudulent and she was going to prove it. I said I had the city inspector's report confirming the fence was compliant. She said the inspector was wrong. I asked if she had any actual evidence. She said she had photos proving the setback was too narrow. I said her photos were taken at an angle and I had already proven that. She said I had edited my photos. I said the metadata proved otherwise. She said metadata could be faked. I said she was welcome to hire her own expert to verify it. She said she would. Monday morning, I received an email from Angela's attorney. The email said Angela was pursuing legal action against the HOA for failing to enforce the bylaws and against me for fraudulently obtaining approval for a non-compliant fence. The email demanded I remove the fence within 30 days or face a lawsuit. I forwarded the email to Ellen. She replied that the demand was baseless and we should ignore it unless Angela actually filed a lawsuit. She said most attorney demand letters were bluffs, and Angela's attorney probably knew the case was weak. I asked what I should do if Angela filed. Ellen said we would respond with a motion to dismiss and a counterclaim for harassment. She said I should keep documenting everything and not engage with Angela directly. 3 weeks later, I received a summons in the mail. Angela had filed a lawsuit in small claims court, claiming I had violated the HOA bylaws and caused her emotional distress. The complaint listed 6 causes of action: breach of contract, fraud, nuisance, trespass, intentional infliction of emotional distress, and tortious interference. I scanned the summons and emailed it to Ellen. She called me that afternoon and said the complaint was a mess. She said half the causes of action did not apply to the facts, and the other half were so vague they would not survive a motion to dismiss. She said she would file a response and a counterclaim for malicious prosecution and harassment. She asked if I had any new documentation. I said I had been keeping a log of every time Angela showed up at my property or contacted me. She said that was perfect, and I should send it over. Ellen filed the response and counterclaim 2 weeks later. The response argued that Angela had no standing to sue me individually because the HOA was the proper party, and even if she did have standing, the fence was approved and compliant. The counterclaim argued that Angela had filed the lawsuit in bad faith to harass me, and that her conduct over the past 3 months met the legal standard for malicious prosecution. Ellen requested damages for attorney fees, court costs, and emotional distress. She also requested a permanent injunction barring Angela from contacting me or entering my property without permission. The court scheduled a hearing for 6 weeks out. In the meantime, I continued to document every interaction with Angela. She drove by my house at least 3 times a week and took photos of the fence from the street. She sent emails to the board and the management company claiming the fence was a safety hazard and demanding they take action. Greg replied each time saying the fence was approved and compliant, and the board would not take further action. Angela sent a mass email to the neighborhood mailing list accusing me of fraud and asking residents to sign a new petition demanding the board reverse the approval. 12 people signed it. 34 people replied telling Angela to stop spamming the list. One of those 34 people was my neighbor Dennis. He sent me a separate email saying he had watched the whole situation unfold and he was disgusted by Angela's behavior. He said he had video footage from his doorbell camera showing Angela measuring the fence at an angle and taking photos from positions that distorted the perspective. He offered to testify at the hearing if it would help. I forwarded his email to Ellen. She said his testimony would be very helpful and she would add him to the witness list. 2 weeks before the hearing, the city code enforcement inspector finally showed up. His name was John. He measured the fence, checked the survey, and reviewed the approval letter. He said everything was in order and the fence met all applicable codes. He asked if I had been having trouble with the HOA. I said yes. He said he had received 3 complaints about the fence from the same person and all of them were unfounded. He said he would include that in his report. I thanked him. He said he dealt with HOA disputes all the time and most of them were driven by personal vendettas rather than legitimate code concerns. He said the best thing I could do was keep my documentation organized and stay calm. I said I was trying. The day before the hearing, Ellen called me and said she had received a settlement offer from Angela's attorney. Angela was willing to drop the lawsuit if I agreed to move the fence 2 feet inward and pay her attorney fees. Ellen said it was a ridiculous offer and we should reject it. I agreed. Ellen said she would let Angela's attorney know. The hearing was scheduled for 2 in the afternoon. I arrived at the courthouse at 1:30. Ellen met me in the lobby. She said Angela's attorney had filed a motion to continue the hearing, claiming Angela needed more time to gather evidence. Ellen said she had filed an objection arguing that Angela had already had 3 months and was stalling. The judge would decide when we went in. I said I hoped the judge denied the motion because I was tired of the whole thing. Ellen said she understood, and we would know soon. We walked into the courtroom at 1:55. Angela was already seated at the plaintiff's table with her attorney, a man in his 50s wearing a gray suit. Angela was wearing the same black cardigan and smartwatch she had worn at every confrontation. Her attorney stood up when we entered and said good afternoon. Ellen nodded. We sat down at the defendant's table. The judge entered at 2 and asked if both parties were ready. Angela's attorney said he had filed a motion to continue. The judge said he had read the motion and the objection, and he was denying the motion. He said 3 months was sufficient time to gather evidence and the case would proceed today. Angela's attorney said he needed to consult with his client. The judge said he could do that during the recess after opening statements. The judge asked Angela's attorney to present his opening statement. The attorney stood up and said Angela was a dedicated community volunteer who had served on the HOA board for 6 years and had always acted in the best interests of the neighborhood. He said I had submitted a fraudulent application for a fence that violated the setback requirements and had refused to comply with the board's requests for verification. He said Angela had attempted to resolve the issue through proper channels, but I had hired an attorney and threatened legal action instead. He said Angela had suffered emotional distress as a result of my conduct and was entitled to damages. He sat down. The judge looked at Ellen and asked for my opening statement. Ellen stood up and said the facts were straightforward. I had submitted a proper application for a fence, received written approval, and hired a licensed contractor to build it. Angela had opposed the project from the beginning and had used her position on the board to harass me, intimidate my contractor, and issue a fraudulent fine. When her tactics failed, she filed a baseless lawsuit in an attempt to force me to remove a legal fence. Ellen said the evidence would show that Angela's photos were misleading, her measurements were inaccurate, and her claims of emotional distress were contradicted by her own aggressive behavior. Ellen said I was entitled to dismissal of Angela's claims and judgment on my counterclaim. She sat down. The judge said he would hear Angela's evidence first. Angela's attorney called Angela to the stand. She was sworn in and sat down. Her attorney asked her to describe her role on the board. She said she was the finance committee lead and had been responsible for enforcing compliance with the bylaws. He asked her to describe the fence dispute. She said I had submitted an application that did not include a proper setback verification and had begun construction during quiet hours in violation of community standards. She said she had attempted to resolve the issue by requesting additional documentation, but I had refused to cooperate. He asked if she had taken any measurements herself. She said yes, and she had photos proving the setback was too narrow. He entered the photos into evidence. Ellen did not object. The judge said he would review them during deliberation. Angela's attorney asked her to describe the impact the dispute had on her. She said she had lost sleep, experienced anxiety, and felt targeted by my legal threats. She said she had resigned from the board because she could no longer serve in a hostile environment. Her attorney said he had no further questions. The judge asked Ellen if she wanted to cross-examine. Ellen said yes. Ellen stood up and walked to the witness stand. She asked Angela if she had hand-delivered a hearing notice to my mailbox as she had claimed in her email. Angela said yes. Ellen asked if she had any proof. Angela said no because it was a hand delivery and there was no receipt. Ellen asked if anyone had seen her deliver the notice. Angela said she did not know. Ellen asked if she had taken a photo of the notice in my mailbox as proof of delivery. Angela said no. Ellen said so the only evidence of delivery was her word. Angela said yes. Ellen asked if Angela had sent the notice by email as a backup. Angela said no because hand delivery was sufficient under the bylaws. Ellen asked Angela to point to the section of the bylaws that said hand delivery was sufficient. Angela said she did not have the bylaws with her. Ellen handed her a copy. Angela flipped through it and said she could not find the section, but she knew it was there. Ellen asked the judge to note that Angela could not cite any bylaw supporting her claim. The judge made a note. Ellen asked Angela if she had called the City Code Enforcement Office to report my fence. Angela said yes. Ellen asked what the inspector had concluded. Angela said she did not know because she had not received the report. Ellen said she had a copy of the report, and it stated the fence was compliant with all codes. She entered it into evidence. The judge said he would review it. Ellen asked Angela if she had taken the photos herself. Angela said yes. Ellen asked if the tape measure in the photos was flat on the ground. Angela said it was close enough. Ellen pulled out a printed copy of one of Angela's photos and pointed to the angle of the tape measure. She asked Angela if she agreed the tape measure was angled. Angela said it might be slightly angled, but it did not make a difference. Ellen asked if a 6-inch difference in measurement would matter when determining setback compliance. Angela said it would. Ellen said so the angle did make a difference. Angela did not respond. Ellen said she had no further questions. The judge asked Angela's attorney if he had any redirect. He said no. The judge said Angela could step down. Angela walked back to her table and sat down. Her attorney called his next witness, an appraiser Angela had hired to review the fence. The appraiser was sworn in and said he had reviewed photos of the fence and determined it was not in compliance with the setback requirements based on the measurements visible in Angela's photos. Ellen objected and said the appraiser had not visited the property or reviewed the survey. The judge sustained the objection and said the appraiser's opinion was not credible without a site visit. Angela's attorney said he had no further witnesses. The judge called a recess. During the recess, Ellen said Angela's case was falling apart, and the judge was clearly skeptical. She said we should focus on the counterclaim and emphasize the harassment and the fake fine. I agreed. The judge returned and asked Ellen to present my case. Ellen called me to the stand. I was sworn in and sat down. Ellen asked me to describe the timeline of the dispute. I walked through the application, the approval, the fake hearing notice, the fake fine, the contractor intimidation, and the lawsuit. Ellen entered the approval letter, the survey, the city inspector's report, and Marcus's metadata summary into evidence. She asked me to describe the impact Angela's conduct had on me. I said I had spent hundreds of hours documenting her harassment, thousands of dollars on legal fees, and I had been unable to enjoy my property because Angela drove by multiple times a week to take photos and send threatening emails. I said my daughter had asked me why the neighbor lady was always staring at our house, and I did not know how to explain it to her. Ellen asked me if I had any evidence that Angela's photos were misleading. I said yes. Ellen handed me printouts of Angela's photos and my photos side by side. I pointed out that the tape measure in Angela's photos was angled and the setback appeared shorter than it actually was. I said my photos were taken with the tape measure flat on the ground and matched the survey. Ellen asked if I had any other evidence. I said Dennis had video footage from his doorbell camera showing Angela measuring the fence at an angle. Ellen asked the judge for permission to call Dennis as a witness. The judge said yes. Dennis was sworn in and took the stand. Ellen asked him to describe what he had seen. Dennis said he had watched Angela measure the fence at least 3 times over the past 2 months, and every time she had positioned the tape measure at an angle instead of flat on the ground. He said he had video footage from 2 of those occasions. Ellen asked if he had brought the footage. Dennis said yes, and he had it on his phone. The judge said he would review it during deliberation. Ellen asked Dennis if he had any other observations. Dennis said Angela had also taken photos from positions that made the fence look taller and closer to the property line than it actually was. He said he had lived in the neighborhood for 15 years, and he had never seen anyone go to such lengths to harass a neighbor over a fence. Ellen thanked Dennis and said she had no further questions. Angela's attorney declined to cross-examine. Ellen called her last witness, Marcus. Marcus was sworn in and took the stand. Ellen asked him to describe his review of the email metadata. Marcus said he had analyzed the timestamps and server logs for the emails Angela sent, and found that 2 of them had been backdated to make it appear she had sent them earlier than she actually had. He said this suggested Angela was trying to create a false timeline to support her narrative that I had been unresponsive. Ellen entered Marcus's written summary into evidence. The judge said he would review it. Ellen said she had no further witnesses. The judge asked Angela's attorney if he wanted to cross-examine Marcus. He said no. The judge said he would take a brief recess to review the evidence and then issue his ruling. He left the courtroom. Ellen said she felt good about the case and thought we had a strong chance of winning on both the dismissal and the counterclaim. I said I hoped she was right. We waited for 20 minutes. The judge returned and said he was ready to rule. He said he had reviewed all the evidence and found Angela's claims to be without merit. He said the fence was approved and compliant with all applicable codes and bylaws, and Angela had failed to provide any credible evidence to the contrary. He said Angela's photos were misleading and her measurements were inaccurate. He said the city inspector's report confirmed the fence was legal and Angela's lawsuit was baseless. He dismissed all of Angela's claims with prejudice. The judge said he was also ruling on my counterclaim. He said Angela's conduct over the past 3 months met the legal standard for harassment and malicious prosecution. He said she had issued a fake fine, threatened me with collections, intimidated my contractor, filed a baseless lawsuit, and continued to harass me even after the board had removed the fine and issued an apology. He said her behavior was intentional and designed to cause me distress. He awarded me damages for attorney fees, court costs, and emotional distress in the amount of $7,800. He also issued a permanent injunction barring Angela from contacting me or entering my property without permission. He said if Angela violated the injunction, she would be held in contempt and face fines or jail time. He banged his gavel and said court was adjourned. Ellen said congratulations, and we walked out of the courtroom. I shook her hand and thanked her for everything. She said it was her pleasure, and she was glad we won. I said I could not have done it without her. She said the documentation I kept was what made the case, and I should be proud. I said I was just relieved it was over. She said it was over unless Angela appealed, but she doubted Angela would because the ruling was so clear. I said I hoped not. I walked out to my car and sat in the driver's seat. My phone buzzed. It was a text from Greg. He said he had heard about the ruling, and he was sorry I had to go through all of that. He said the board was discussing Angela's conduct at the next meeting and they were considering a formal censure even though she had already resigned. I thanked him and said I appreciated the support. He said the neighborhood was better off without her on the board and he hoped I could finally enjoy my fence in peace. That night I picked up my daughter and we sat on the back deck. She asked if the neighbor lady was going to keep taking pictures. I said no, she was not allowed to anymore. She asked why. I said a judge had told her she had to stop. She said good, because it was weird. I agreed. 2 weeks later, I received a check from Angela's attorney for $7,800. I deposited it and paid off Ellen's remaining invoice. I had about $3,000 left over. I used part of it to take my daughter to the Science Museum like we had planned. The rest I put in savings. A month after the ruling, I received a letter from the HOA. It was signed by Greg and the other board members. The letter said the board had reviewed Angela's conduct and determined it violated multiple sections of the bylaws, including the prohibition on selective enforcement and the duty to act in good faith. The letter said the board had voted to adopt a new policy requiring all fines to be approved by a majority vote of the full board after a hearing with proper notice. The letter also said the board had agreed to reimburse my attorney fees and court costs as part of a settlement to avoid further litigation. The settlement removed all fines tied to the fence dispute and added a written no retaliation policy with financial penalties for any board member who violated it. The letter said the board hoped this would close the matter and allow the community to move forward. I printed the letter and filed it with the rest of my documentation. Then I walked outside and looked at the fence. It looked great. The posts were straight, the panels were level, and it was exactly where the survey said it should be. I pulled out my phone and called Tom. I told him the dispute was finally over and I wanted to thank him again for finishing the job. He said it was no problem and he was glad it worked out. I asked if he was still taking new clients. He said yes. I said I would refer him to anyone who needed a good contractor. He laughed and said he appreciated it. That weekend I was working in the yard when Dennis walked over. He said he had seen the settlement letter in the mailbox and wanted to say congratulations. I thanked him and said I could not have won without his video footage. He said he was happy to help, and he was glad the neighborhood could get back to normal. I said I was too. Later that afternoon, I was sitting on the deck when I heard a car pull up out front. I walked around and saw a moving truck parked in front of Angela's house. 2 men were loading furniture into the truck. I walked back to the deck and sat down. My daughter asked if the neighbor lady was moving. I said it looked like it. She said good, because she did not like her. I said I understood. A week later, the house was sold. A young couple moved in with 2 kids. They introduced themselves and said they had heard the neighborhood was quiet. I said it usually was. They said they were looking forward to it. I said I was too. I never saw Angela again. Greg told me later that she had moved to a different city and joined a different HOA. He said he felt bad for whoever had to deal with her next. I said I did not. He laughed and said fair enough. The fence is still standing. It is exactly where the survey said it should be. My daughter plays in the backyard every time she visits. The HOA has not sent me a single violation notice since the settlement. I still check the portal every week just to be safe, but there is nothing. I learned a lot from the whole experience. I learned that documentation is everything. I learned that HOA board members can abuse their power if no one holds them accountable. I learned that standing up for yourself is exhausting and expensive but sometimes necessary. And I learned that a good fence, built to code and approved by the city, is worth fighting for. I hope the rest of your day is peaceful.